After exploring the concept of prescriptive easements and how individuals can gain certain usage rights through continuous occupation, it is essential to shift our focus to another category of land that operates under entirely different legal principles: Arizona State Trust Land. Unlike private property or federal lands, state trust lands are governed not by ownership rights earned through possession or adverse use, but by constitutional and statutory mandates that dictate how these lands may be managed, leased, and sold for the benefit of specific public institutions. The legal foundation for Arizona's state trust lands originates from Article 10 of the Arizona Constitution, known as the State and School Lands Article, which was adopted upon Arizona's admission to the Union in 1912. The U.S. Congress granted approximately 10.9 million acres of land to Arizona at statehood through the Enabling Act of 1910. These lands were placed into a permanent trust to support designated public beneficiaries, primarily the Common Schools Trust, which funds Arizona's public K-12 education system. Other beneficiaries include universities, the state hospital, correctional facilities, and public institutions that serve the people of Arizona. Article 10 of the Arizona Constitution establishes strict fiduciary obligations and procedures for the management of state trust lands. The State Land Department, led by the State Land Commissioner, serves as the trustee responsible for administering, leasing, and selling these lands under the constitutional duty to maximize financial returns for the beneficiaries. This fiduciary responsibility is similar to that of a private trustee and has been repeatedly upheld by Arizona courts as binding and enforceable. The lands are not public lands in the same sense as those managed by the Federal Bureau of Land Management, BLM. Instead, they are trust assets, held and managed solely for the purpose of generating long-term income for the designated beneficiaries. For example, when the Arizona State Land Department leases grazing land in Cochise County or commercial development land in Phoenix, the income generated from those leases, whether from rent, mineral extraction, or sale proceeds, must be distributed to the proper trust fund, ensuring that public schools or other beneficiaries receive their equitable share. The Arizona Supreme Court has emphasized this fiduciary principle in Kadish versus Arizona State Land Department, 1987, ruling that the state must administer the trust solely for the beneficiary's financial benefit and not for general public use. In that case, citizens challenged the leasing of trust land at below market rates, arguing that it violated the trust's fiduciary duty. The court agreed, reinforcing that trust lands cannot be managed for political or environmental objectives at the expense of maximizing revenue for the trust. The court emphasized that the state acts as a trustee and owes the same duties as a private trustee: loyalty, prudence, and obtaining full value for trust beneficiaries. Article 10 of the Arizona Constitution explicitly prohibits the sale or lease of trust land except as provided by law and through public auction, ensuring transparency and fair market value. Section 3 provides that no trust land may be sold for less than its appraised value, and Section 5 requires that proceeds from any sale or lease be deposited into a permanent fund, where they are invested to generate ongoing income for the trust beneficiaries. This constitutional framework protects the long-term financial integrity of the trust and prevents misuse of these assets for short-term or private gain. State trust land may be used for a wide range of purposes, including grazing, mining, commercial development, and rights of way for utilities and roads. But it is always subject to the overarching duty of revenue generation for the trust. Unlike public land that citizens may access for recreation or hunting, access to state trust land generally requires a permit or lease issued by the State Land Department. Even recreational use, such as hiking or camping, requires a state land recreation permit. Real estate licensees often encounter state trust land in transactions involving leasehold interests rather than fee simple ownership. For example, A developer might lease state trust land for a 99-year term to construct an office complex, with the understanding that the improvements revert to the state at the lease's end. Brokers representing buyers or investors must recognize that such transactions differ significantly from traditional private sales, because trust lands cannot be conveyed outright without a public auction. Under ARS, paragraph 37, 132A, 5, any sale, exchange, or lease exceeding 10 years must be advertised publicly and awarded to the highest qualified bidder at an open auction. In addition, the Arizona Constitution prohibits the granting of adverse possession or prescriptive easements against state trust land. Because the land is held in trust for public beneficiaries, it cannot be acquired by private individuals through use or encroachment. This stands in sharp contrast to private property law, where long-term adverse use might lead to a transfer of rights. The Arizona Supreme Court reaffirmed this principle in City of Tucson versus Arizona State Land Department, 1982, holding that the state cannot lose its trust property interests through estoppel, lock keys, or prescription. For real estate professionals, it is crucial to understand the limitations and responsibilities associated with transactions involving state trust land. Licensees must ensure clients are aware that they are dealing with trust property and not private land, that all leases or purchases must go through the Arizona State Land Department, and that specific use restrictions apply. Misrepresenting trust land as privately owned or failing to disclose its restrictions could constitute a violation of AAC R428-1101B, which governs the disclosure of material facts. Review Summary. Article 10 of the Arizona Constitution establishes the legal foundation for state trust land, mandating that it be managed and administered for the financial benefit of designated public beneficiaries, primarily public education. These lands cannot be sold, leased, or otherwise conveyed except as authorized by law and through public auction. The State Land Department serves as trustee, ensuring transparency, fiduciary responsibility, and compliance with constitutional and statutory provisions. Real estate professionals must recognize that state trust lands differ from private property, as they cannot be acquired through adverse possession, must be leased or purchased through state procedures, and are intended to serve the long-term interests of Arizona's citizens through the Permanent Trust Fund. Discussion prompts. Why can't Arizona state trust land be obtained through adverse possession or prescriptive easement? Answer: because it is held in trust for public beneficiaries, and the state cannot lose trust assets through private encroachment or use. What is the purpose of requiring public auction for the sale or lease of state trust land? Answer: to ensure transparency and to guarantee that the land is sold or leased at fair market value for the benefit of the trust. How does Article 10 of the Arizona Constitution protect the financial integrity of state trust land? Answer: by requiring that all proceeds from sales and leases be deposited into a permanent fund and used exclusively for designated beneficiaries. Closing remarks. The Arizona State Trust Land System embodies a century-old commitment to public education and responsible land stewardship. It reflects the balance between development and preservation, ensuring that Arizona's natural resources and land assets generate revenue for future generations. Understanding the constitutional basis of these lands reinforces a key professional responsibility for real estate practitioners to protect the public interest by ensuring full disclosure, compliance, and ethical conduct in all dealings involving trust property. Supporting sources and key case law. Arizona Constitution. Article 10. State and School Lands Provisions. Arizona Enabling Act of 1910. Congressional Grant Establishing the Trust. ARS. Paragraph 37, 132A. 5. Authority for Lease and Sale of State Trust Land by Public Auction. ARS. Paragraph 37, 1153D. Permits required for recreational use of trust lands. Kadish v. Arizona State Land Department, 155 Arizona 484, 1987. Fiduciary duty of the state to manage lands for beneficiary profit. City of Tucson versus Arizona State Land Department, 136 Arizona 140, 1982. State cannot lose trust land through prescription or estoppel AAC. R428 E1101B. Broker disclosure obligations.